can't understand me. Thank you. I would like to rely on my brief for issues 4 through 6. I only argue the first 3 arguments, if that would be okay.
That'd be fine.
Issue 1, whether there was competent evidence to refute the reasonable hypothesis of innocence. I'm not asking you to weigh the credibility, as my opponent says. I understand that this court will hold the evidence most favorable to the state. And even so, it's not competent evidence to refute my client's innocent hypothesis of innocence. Namely, the main witness was JB, a 7-year-old who accused my client of maliciously punishing the victim, BK. But she cannot distinguish whether the baby cries due to a diaper change or something else.
Counsel, am I correct in that we do have a concession between the parties that this is a circumstantial evidence case?
Yes, ma'am. Yes, ma'am. And if you look at the other cases of felony
Okay, can you focus on what's your reasonable hypothesis of innocence here?
Yes, sir. We pre-exist, there is evidence of a pre-existing condition that was exacerbated when the older brother had.
But didn't 3 or 4 of the state's experts reject the idea that a pre-existing condition causes death?
On direct, they did. On cross-examination, they cannot really refute that with any medical or scientific certainty. So if you look, yes, if you look at the direct, they did, but if you look at the cross-examination, they did agree that it could have happened that way.
And did the defense provide evidence at the trial other than attempting to show that possibly this was a congenital condition or could have come from intracranial pressure? Was there evidence at trial that there was the possibility that this was accidental, or was that not argued?
No, it's not argued, and that's very relevant to the second issue of whether the Williams rule was relevant, since my client did not argue the accident on her part. So there was no reason to intent was not an issue at the trial. And may I move on to the second issue?
Yes.
Okay. My opponent argues this is not preserved because I used a different verbiage the trial lawyer. But the trial lawyer and I argued the same basis of relevance, that the public value was greatly outweighed by the prejudicial effects of JB's testimony. JB is 7-year-old.
Well, isn't the argument, the state's argument here, that their theory is that it's shaken baby syndrome, basically, and that she has acted in the past in a manner that demonstrates that she very well may have shaken this baby? And why isn't that relevant?
It isn't relevant, Your Honor, because the state elected not to charge my client with the theory of malicious punishment. They had every
I
opportunity.
know, but isn't that also an aggravated battery? Especially if there's bodily injury. And that goes to my, because my main question in this case is, it appears the state, or the jury bought the state's theory that this woman did something that caused the death of this baby. So clearly there was great bodily harm.
Yes, yeah.
Only, other element that really comes into effect was did she effectuate a touching that caused this great bodily harm?
But really,
Even if they found that this was malicious punishment, is there any way that it could not have also been an aggravated battery?
no, sir. Because, okay, first of all, for one to be even admissible, there has to be competent. And we have to look, and we have to go back to the hearing on the women's war, where the child could not distinguish the cause of the abuse crying. Her testimony did not even say how frequently it happened, how close to the incident happened. She could not give credible testimony, first of all. Secondly, the way it was tried aggravated by that if you look at JB's testimony, she could not say, yes, the baby cried because I saw Miss Lowery do A, B, or C. She couldn't make that connection. But I still believe JB. She said the baby, that she was trying the baby by the feet and prop him on the couch, not on his head, not on his back. We don't know how she allegedly propped a baby on the couch. That was not established either. That's why JB's testimony was so incompetent. There's no detail of what will happen. I'm going to get into three. I wanted to say JB's testimony was indeed harmful because that was the chief evidence the state used to connect my client to the injury. Issue 3 is the jury instruction on malicious punishment. We know it's a violation of due process to offer a jury instruction theory, not charge.
But that goes back. I understand it would be a due process violation. Let's say if there was evidence to support that the death was a result of caging this baby, where it was not a result of a touching. But it seems to me that based on the testimony of the doctor, the only reasonable implication here, if the jury bought the doctor's testimony, was that it was based on a touching that caused great bodily harm. So that goes back to my question as to how does that really hurt your client here? You know, to be a due process concern.
I understand, yeah. If you let me testimony again, and the whole entire testimony, she says that the injury cannot happen by shaking alone. She says that. And she also said even her conclusion that was shaken by impact was not based on medical certainty. Okay? Did you have that from me?
Do they have to use the magic words, medical certainty? Because it seemed to me that during their testimony they were pretty sure.
Yeah, but she was confronted with the different things that intracranial pressure over 2 weeks over sexual hematoma could be activated by the touching. You did have a touching by the brother who touched the baby in the forehead. And then you only had a sexual hematoma and could activate it into the seizure that did occur that day. And yet, to argue at trial on 20 different theories, this one charge in the indictment is just due process violation, and I will ask reversed, be remanded for another trial. Any questions?
You're down to about 7 minutes.
Thank you.
Thank you. Leslie, can you check on the mic again?
He says it's working now.
You want to check real quick?
Still nothing. Okay. Go ahead, you may proceed.
Yes. Thank you. May it please the court. Quentin Humphrey on behalf of the state of Florida. What we have here, I'll go through the issues sequentially. What we have here in issue 1 is a battle of the experts. If you look at the trial testimony of Dr. Arefe Rifai, he says, and I'm going to quote from page 2453 of the trial record, the only thing that could have caused hemorrhaging, he testified there was hemorrhaging in both eyes. He said the only thing that caused such severe multi-layered hemorrhaging to that severity and that extent is a condition called non-axial trauma that includes shaken baby. And Dr. Andrea Minyard concluded that the cause of death was a blunt impact of head homicide, and that she believed it was shaking with an impact, and that's from 2586 on the trial record. The defense counsel presented an expert, Dr. Willie, who testified that there is no such thing as shaken baby syndrome, and that this baby died because of an abnormally large head. What we have here is a battle of the experts. We have two sides presenting testimony about two different causes of death, and we put it to the jury to say, which one should we believe? That is enough to overcome a hypothesis of innocence. You don't need to say, we know this beyond any possible medical certainty. You present your testimony, supported by your factual evidence, and you give it to a jury to determine if the state ultimately produced it overcame by beyond a reasonable doubt, and for a judgment of acquittal, if it's inconsistent. And we put forth evidence that there was.
There was no other person overseeing or supervising the child at the time of the incident?
Well, what we have here is we have one person that was present at the time of the incident, and that was the appellant. She testified, I believe, at trial that she's the only one there besides some small children. The child victim's brother and Daniel. What we have, and so we know that she was the only person there, and the injuries were consistent with it. They explicitly, they said that throughout trial, we have multiple witnesses that set by the state that talked about how that this was consistent with, including the brain damage, was consistent with non-accidental trauma.
All right, well, but even if we had consensus with the state's medical witnesses that this was caused by an acute blunt trauma force, we've got a approximately 3-hour window, 7 a.m. for when the child was dropped off at the daycare to 10 when I think the 911 call was made. When you use the term the incident occurred, we don't quite know what the incident may be. We don't have testimony of from 7 to 10 exactly if there was supervision of the child or exactly what happened between that time. We know something happened between that time, correct?
Yes, yes.
And so we have circumstantial evidence to prove the identity of the alleged abuser.
Well, I don't think it's a question of identity. It's because we know that the only person present was the defendant. Her defense at trial was, I didn't do this. I treat this child like my own. I loved him like my own. I would never harm a child. And this goes into issue 2 with the 90404 child witness.
Isn't there testimony from 1 or 2 doctors that trauma of this type, you would have seen symptoms almost immediately?
And the jury, and yes, but it goes back to the jury finding role. The jury can accept or reject their testimony based upon what they have. And the child had a seizure. The defense even concedes that, had a seizure there, and then there was another seizure on the way to the hospital. The emergency department only took, 5 minutes to get there? We have very quick onset of symptoms, and when they get to the hospital, they end up having to take that baby into surgery, open up his head, and to let the brain swell out, and they have to do it twice.
But I think there was a consistent opinion from medical experts that you would see symptoms within hours, was the testimony. So again, we're dealing with a 7 to 10 time clock. They didn't say immediately; it said within hours.
And that fits within the time frame within the window of this case. We have here, going back to, we have a battle of the experts. We have 2 different theories to cause the death. We have one that says it is a non-accidental trauma, shaken baby syndrome. And we have a doctor who says that it's not shaken baby. It is a result of an abnormally large head and an injury that resulted to it from being hit with a block, potentially. And that is enough to get the state past JOA in this case.
Let me point you to issue 3.
Yes, Your Honor.
It seems to me that the statute lays out 3 ways that this crime can be committed. And one is maliciously punishes.
Yes, Your
The
Honor.
concern here, I mean, you got to admit that the state did not charge to maliciously punish.
Your Honor, let's take a look at what an indictment information is for. And I'm going to quote from a 4th DCA opinion that I'll be happy to supplement after this. An information serves the important function of placing the accused on notice and giving him or her an opportunity to adequately prepare a defense. What we have here, and the defense conceded it in their initial brief and their reply brief, and even here today, that the state discussed malicious punishment at the hearing. I'm going to quote from the hearing here
Well, doesn't that hurt you? Because if the state relied on malicious punishment and it's not charged,
Well,
how do we find it's harmless error?
Your Honor, we go look at a first DCA case, Cogbill v. State. It's from 2006, and I'll supplement with this as well. In that case,
In that case, we said you couldn't traffic without actually being in possession of the drug. So there was no harm, no foul there here.
And what we,
But could you maliciously punish without committing an aggravated battery?
that's what I'm, and yes, Your Honor, as the defense correctly conceded just a few minutes ago, that the jury could have convicted for great bodily harm. We have a child victim with heavy hemorrhaging throughout his eyes. We have a brain that shifted off center and that actually expanded. They had to cut the derma out to try to save the baby's life. There's no way the jury could have convicted without finding great bodily harm. It is as simple, and because of that fact, that there is no way they could have in this case, that it doesn't result in a due process issue.
Okay, you're saying based on the facts of this particular case?
Based upon the facts of this case, what we have here is great bodily harm. There is no way around that. And the testimony is uncontested that this child, and no matter what defense witness or state witness put on, we have great bodily harm for this child. And it is, and much like in Coghill, where we can conceive of no circumstance, particularly under the facts of this case, whereby one can engage in the act of manufacture as the term was defined without also being in actual or constructive possession of a prohibited substance. There is no way in this case that the jury can conclude, no matter what theory they may have picked or not picked, that great bodily harm didn't occur, because all the testimony was uniform on that. They may have had different explanations of why, but it was very clear and it was uncontested that there was great bodily harm.
Was this claim brought up only for the first time at the charge conference?
The state said during 6.5 months before trial that in this case, intent to maliciously punish is an element.
In what context did they say that?
That was at the Williams Rule hearing, Your Honor, on page 1775 of the appellate record. The state informed the defendant. And furthermore, we charged the language
just in passing at a hearing that just they said in passing something about malicious punishment or something. I'm not understanding how the defense was put on notice that this will be a claim for which a jury instruction will be provided.
And we also argued that aggravated child abuse in the information under section 82703. And we argued that was the underlying felony in this case, and that encompasses maliciously punish.
It also encompasses other ways of doing it.
Absolutely, including
And the
great bodily harm.
information listed the other ways, but they did not put in there maliciously punish.
We still put them on notice, Your Honor. We told them that aggravated child abuse, why
was that excluded from the information? There are 3 ways of doing it, and 2 ways are listed in the information. Why is the third excluded?
Your Honor, we're speculating here at that, but the fact remains is we still
I know,
put
but
them on notice.
we're speculating, but if I look at an information and you cite to the statute, and you cite 2, isn't a reasonable inference that these are the 2 theories you're proceeding on, and you're not proceeding on the third? Isn't that the only reasonable inference I could draw?
Well, no, Your Honor. You can draw it by looking at the language we actually charge aggravated child abuse under section 82703 and go forward with that. And we don't even need to reach that issue, because at the end of the day, they clearly convicted under great bodily harm as well. There's no way to get around that evidence.
I understand that argument, but I'm having trouble that you put them on notice by this information. It seems like the information itself leads me to another way of looking at it. It doesn't look at, I know they're going on malicious punishment. It seems to me what that information is saying to me, you're going on one of the other 2 theories, and I don't see any other way to read that information.
The way to look at the information is to look at the language that was included in the information, that it stated that it was aggravated child abuse, and that we clearly alleged it under 82703, and we prosecuted under that.
Well, how do you get around the cases like aggravated battery where you can do it by bodily harm or using a deadly weapon? Because in that case, the section clearly contains 2 ways of doing it, and if the information leads one of them out, the case law seems to indicate the state's in trouble. How do you differentiate those cases?
That we clearly alleged in the information that it was...
I understand you keep on saying that, but how is that any different than the other aggravated battery cases that I'm talking about?
Because in this case, and it's important to look again at Coghill, a cog bill, sorry. What we have here is a case with, as the defense conceded, they could have convicted under great bodily harm, and there's no way you can
Is
convict
that the
for.
test they could have, or
They-
do we need to know that they did in fact?
They would have there's no way they could have convicted without finding great bodily harm on this.
I understand,
Even if it
I
was
understand that
maliciously
argument, but I'm
punishment.
still trying to understand the argument that this
Well-
information put them on notice.
Even if they convicted under malicious punishment, which we're not conceding here, that then there's no way you could have found that without including great bodily harm. Because
So
the
your
injuries-
argument's harmless error. So error, but harmless error.
Well, my argument is we did put them on notice. That we put them clearly on notice by arguing aggravated child battery, and that even if it was error, it was harmless, because there's no way you'd be able to find malicious punishment without great bodily harm in this case under the facts of what occurred to the child victim.
Well, here's the problem I see, that the statute lays out three factors, three requirements that have to be met. There has to be the aggravated battery, willful torture, maliciously punishes, and so on. And the third one is causes great bodily harm. So maliciously punishes is a different element from great bodily harm. So how could finding great bodily harm satisfy the requirement that was left out of the information that there's malicious punishment here?
Well, we alleged aggravated child abuse.
Right, but that's a 30,000, I mean, it's okay to concede. We understand you put the statutory citation in aggravated child abuse. We get that. I think we all get that. The question, though, is because you didn't put in the actual portion of the statute maliciously punishes that under which this case was prosecuted, how is that not an uncharged crime?
Well, I think we need to look at the fact that it's just one of the ways that we prosecute under. We prosecuted under all three.
Willful torture and caging?
No, not that one. No, I mean, we prosecuted.
Well, you said there were two in the information.
Yes.
Which were what?
Let me pull the information.
The only other two are willful torture and unlawfully cages a child. Or maybe you were saying that you only had two of the three elements in there?
Two different elements, yes, Your Honor.
Okay, so you totally left out whether it was willful torture, maliciously punished, or unlawfully cages.
Yes, Your Honor. Sorry. But this.
Well, I think as I read the statute further, which your argument, I think maybe I'm understanding it now. You're saying that it could be, they're disjunctives.
Yes.
So the fact that you didn't put in the maliciously punishes.
But we still alleged it through the information, through the language we charged, and that we still proved great bodily harm in this case based upon the facts of the evidence presented.
Okay, the fact that you proved great bodily harm doesn't get you there. It seems to me the only argument the state has on this, and my panel members may disagree, is that there is no way that if the jury did find maliciously punished, then under the facts of this case, they could also not find an aggravated battery.
That is, yes, Your Honor, that and the fact that we alleged it in the information through aggravated child abuse.
You keep on going back to an argument that I don't think you're selling very much.
But the fact is, we did prove it through great bodily harm as well. That the child, there's no question the child died of these injuries. Between the hemorrhaging throughout the eyeballs, the brain being shipped off mid-center, the fact they had to cut open the skull to let the brain expand twice in a failed attempt to save the child, that clearly results in great bodily harm.
Oh, but keeping, I guess, continued questions along this vein, the Williams Rule hearing, didn't the state argue that testimony should come in to show punishment? The main argument for the introduction of that Williams Rule evidence was a punishment type theory.
Well, the state introduced that ultimately, and you can look at the notice. We introduced it in a lot of ways to show intent, and we can proceed under that.
Although not charged, your main theory of getting that key testimony in seems to be punishment, but yet the argument can be made that it was actually in the end more of an identity type evidence? And how would you distinguish our case in Rivet versus State in that regard, where we
Well,
denied admission of Williams Rule evidence on a very similar ground?
Well, the issue here at trial, the issue wasn't intent at trial. Not intent, the issue wasn't identity at trial. We introduced this for intent. And I think it's important to look at the fact of why we introduced it. What we have here is a defendant who claimed that, among other things, that she didn't harm this child. She had no ill will towards the child. She would never harm the child. And we have our 90404 witness who comes up and says that when she was alone with this child, and she sometimes would change the diaper, or when the child was mad, she would discipline the child, and she would grab him by the ankles, lengthen him out, and plop him down on a couch. And when we look at 9404 to it, we have similar facts, evidence of other crimes, wrongs, or acts is admissible when relevant to proof a material fact in an issue, including but not limited to proof of motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake or accident, but it's not admissible to prove propensity.
Couldn't you have introduced this saying it was being introduced for show lack of accident or mistake, because the theory of the defense was that there was two children playing and she got hurt?
Yes, and yes.
I mean, it seems to me, and again, I'm kind of going out on a limb here, that this whole thing of everybody keeps on going back to the word intent. That's not a magic word. There's a lot of words that you could use for the introduction of this evidence.
And, Your Honor, I think a case that should be relevant for this court is Tannen Hill v. State from the 4th DCA, and I will happily supplement with that as well. In that case, to respond to your issue, the appellant argued in that case that in order to introduce a collateral crime to establish identity, the collateral crime and the crime at issue must share some unique factors suggesting the same perpetrator. The 4th rejected that. They said, we do not need to decide if these crimes are so uniquely similar as to allow omission of the collateral crime to establish identity, because there was no issue of identity in this case, as there wasn't in our case. Defense never contested it. They just said, we didn't do it, we are peaceful people. They put on multiple reputation witnesses to the peacefulness.
Well, I mean, aren't we kind of playing a semantics game when the defendant says, I did not do it? And so there's an allegation of, we don't know what happened to this child. Did the child fall when nobody was in the room and strike his head? Did the caregiver, was she responsible for these injuries? So aren't we really talking about identity in the end?
Well, that's the thing, Your Honor. The challenge, and I'm going to finish quoting this case. The challenge evidence was admissible, however, in order to refute appellant's theory of defense that it is merely an innocent bystander with no knowledge or involvement in the drug sale. It was a drug sale case. What we have here is we have the 90404 witness who comes in and testifies as to her intent towards the child when she's alone with him. She is mad at the child for whatever reason, and this is how she responds to him. And that place and the intent was an issue, especially when she puts her character in issue.
The key witness of JB, the child who said, I witnessed the caregiver
who was a
plop the
904
child on the
witness.
couch. Again, emphasizing the importance of the state's position at the Williams Rule hearing, correct?
Well, what it does is that it shows how she acts towards the child, that when she is mad at him, and that this was not a mistake, this was a purposeful action by her. It is and so therefore it was admissible. It was not an abuse of discretion, and we don't have to show.
But the state argued at that hearing solely that the evidence was admissible to show punishment. We go back to the malicious punishment item that was not included on the information.
Well, the state also argued intent at that hearing. I'm out.
Okay, I'll give you 30 seconds to conclude.
Your Honors, what it comes down to is that at the end of the day, we have a battle of the experts that testify about two different ways that the offense could have been committed. We have a 90404 witness who is being used to show the intent of the defendant towards the child victim when she testifies she would never harm the child. And we have, at the end of the day, we have a conviction that there is no way that under whatever theory they can be convicted under, there's no way they could have found it without great bodily harm towards the child victim. And as a result, we ask you to affirm in this case.
Thank you. Yeah, I actually see the light is on the microphone, so we're hoping it was working.
Yes, sir. I would like to answer the instruction issue. A prosecutor in every case has the sole discretion to choose what theory to charge. They even have the discretion to amend the indictment before trial. That never occurred. If the distinction between Carbill in this case is that in Carbill he was charged for trafficking in meth, and the information that instruction of given was possession of meth. Well, if you traffic in meth, you definitely have possession of meth. So that's why this court did not find fundamental error in that case. However, in this case, as pointed out during questioning, the fact that the state attorney said at hearing we offered for malicious punishment doesn't do the job. They still have to amend the charging documents to put the defendant on notice that is a crime charge.
With the Williams Rule testimony, I'm kind of moving off the jury instruction to the Williams Rule. Was the Williams Rule testimony also admissible based on the theory of great bodily harm as well, to show absence of mistake?
I would argue no, so, because you have to have intent. I want to point your attention to Jackson v. State of this court, which says when the defendant denies involvement in a criminal act, that intent is not an issue. It would have been an issue had my client said, "Oh, I dropped a baby," or I just was tapping the baby. She didn't say that. Therefore, the issue of intent was not in dispute. She did not put in dispute to allow that Williams Rule in.
But if the actions that are testified to, the doctors say are consistent with the way the injury could have happened, because they do say that.
Yes, but the state of witnesses also say that the injuries are also consistent with the pre-existing 2 weeks. You can't get around 2 weeks, you're remembering that the state witness doctor found. It wasn't found by the defense, found by the state and a pre-existing condition. And they all agreed on cross. Yes, it could have contributed to the injury if the baby was hit by a ball. As Jake Thomas pointed out, it was an hour of being hit with a ball that the baby vomited. I have that's okay. Every symptom Dr. Pearson, who was treated physician there, my client said that she said before she get her about Dr. Peterson, she testified, she stated in MET, this is what happened. Her statements to EMT match the sentence of Dr. Peterson as certain to cranial pressure and curbing caused by 2-week-old membrane. That was earlier than the incident.
Did the jury verdict distinguish between the different categories of offenses?
No, unless one is a deposit violation, there's no way this panel can determine that my client wasn't found guilty of the uncharged crime of child abuse by malicious punishment. There is absolutely no way because you have a testimony TV. And if you read the closing argument.
Okay, but the jury found here that your client was responsible. I know you don't think that's a good verdict, but the jury found that she was responsible. We also have great bodily harm. I mean, obviously, if they found that the child was died as a result of the actions, there was great bodily harm. So it seems to me the only question then was, well, how did the great bodily harm come about? And and I keep on going back to, under the facts that were presented to this jury, how could a jury found that malicious punishment took place that did not include an unwanted touching?
If you were a Palm Beach State Yard, that crime was to act child abuse with a deadly weapon. Well, usually aggravated child abuse, and the court found that the introduction of a deadly weapon was fundamental error because you cannot determine one the jury found. And that was he used a pipe, and the defendant used a pipe to go after the child.
Okay, you're running over. I'll give you 20 seconds to conclude.
I will urge this panel to let the Palm Beach State to find that even though they could found great bodily harm, it's still a fundamental and still due process violation. I will ask the court on issue 1 to go back and look at the whole testimony of the state doctors when they don't refute my client's hypothesis of innocence, and reverse and discharge my client. And the alternative, I will ask on issues.
Okay, I'm going to have to cut you off because we have other cases this morning. Thank you both for a good oral argument.
Thank you.
We'll stand in recess for about 15 minutes, and we invite you to join us on the third floor for coffee.
All rise.